Hello, Professor Lau here with my assistant Chewbacca, the wonderful Wookiee. In today's class, we're going to be talking about battery. How fun. So what is battery? Is it this? Technically, yes, but it's not the battery that we're talking about today. The one we're talking about is an intentional tort. Let's start from the top and explain that. A battery is an intentional tort. You should understand what an intentional tort is, and then I'll explain what a battery is. So what is an intentional tort, you ask? Intentional torts are wrongful acts done on purpose. The person does not need to actually mean the harm, but the other person ends up hurt anyways. Let's break down intentional torts down even further. First word, intentional. One needs to have intent. Intent generally refers to the mental state behind an action, the purpose. And in this case, it would mean the person would have the purpose or knowledge with substantial certainty that something would happen. Even simpler put, intent is the desire to cause a certain immediate result. Next, what's a tort? A tort is a kind of wrongful act that causes harm to someone else. There are many different kinds of torts. However, today we're just going to focus on the intentional tort of battery. So, together with the mental state of intending a wrongful act that causes someone harm, someone may have committed an intentional tort. So now that we know what an intentional tort is, let's talk about the specific intentional tort of battery. Battery is one of a few different types of intentional tort. An easy to understand example of an intentional tort is when someone, let's call it me for example, punches someone, yes, even a Wookiee, in the face. If I punch Wookiee, he may file suit against me for battery. In order to do so, he would need to prove a prima facie case of battery. Oh, more legal words to explain. Prima facie case. Let me explain. A prima facie case is a cause of action or defense that is sufficiently established by a party's evidence to justify a verdict in his or her favor, provided such evidence is not rebutted by the other party. In simple terms, if the prima facie elements of a tort can be proven, a defendant may lose their case, unless there's a sufficient defense. If the prima facie elements can't be proven, the defendant most likely would win. Every tort has similar prima facie elements. An easy way to remember them is using the acronym RAPID, which stands for R. The actor was engaged in the required tortious conduct, which is different for each type of tort. We'll cover what they are for battery in a moment. A, actual cause, also known as the cause in fact. The but-for test is used to determine whether an event is the actual cause of damage. But-for means if it was not but for this event, X wouldn't have happened. P, proximate cause, also known as the legal cause. The test for this element is, was it foreseeable that X event would occur as a result of the action? Lastly, D. This is pretty straightforward. It's the resulting harm, whether it be an injury or some sort of financial loss. Now that you understand the basic elements of any tort, let's get on to the elements of battery. So, to prove a prima facie case of battery, follows this acronym, but with a little bit of a twist. What are the elements of battery that need to be proven, you ask? Well, let's reference everyone's favorite section of Second Reinstatement of Torts, Section 13. Verbatim, it states, an actor is subject to liability if another for battery, if he A, acts intending to cause a harmful or offensive contact with the person of the other or a third person, or an imminent apprehension of such a contact, and B, a harmful contact with the person of the other directly or indirectly results. I'll say that 3 times fast. Let's break this down into a little bit more bite-sized pieces. 1, the defendant has acted. 2, the defendant has intended to cause harmful contact or offensive contact, or plaintiff's imminent apprehension of such a contact. 3, with the person of the other or a third person, and harmful contact had resulted, and the plaintiff did not consent. As you can see, there are a few different elements to prove a case of battery. Let's go through them. The first element is the same as any tort. The actor would have had to act. An act is a voluntary muscular contraction, and an actor does not act if movement is not voluntary. Examples of involuntary are sleepwalking, epilepsy, or even a seizure. Next, the actor had to have intent or a desire to cause a certain immediate result. The requisite intent for battery is merely to touch or make contact without consent. It need not be an intention to do wrong, and the wrongdoer need not intend to cause the particular harm that occurs. Next, the actor would have to intend to cause a harmful or offensive contact or a plaintiff's imminent apprehension of such contact. Let's take a moment and review this element in more detail word by word. Harmful. Harm in the case of battery could relate to physical harm. A plaintiff or complainant in a case for battery does not have to prove an actual physical injury. If not physical, the contact would have to be offensive. Now, offensive means it would offend a reasonable sense of personal dignity. The harmful or offensive contact does not have to be direct with the defendant, but rather contact can be made with something connected to the defendant, such as a walking stick that they're holding, a shirt collar, or even a lightsaber. Now, the defendant's acts could also create an imminent apprehension, or in more simpler terms, an immediate expectation of the harmful or offensive contact. However, the harmful or offensive contact does need to occur for a case of battery. The last element that needs to prove a prima facie case of battery is that the plaintiff did not consent. Consent in simple terms means agreed to. However, the defendant would need to consent to the level of contact and resulting harm or offensiveness should consent potentially be used as a defense. I.e., someone may consent to be hugged, but not be sexually groped for an extended period of time. The consideration that should always be made when dealing with a case of battery is also the circumstances and the environment in which the act happened. A case of battery may result very differently for someone filing a case of battery for being pushed on a busy New York subway versus being pushed in an empty field in the farmlands of middle of America. So those are the elements of battery. Let's go through it in a mock battery scenario. Me, again, punching Wookie. He doesn't sound happy. Would I be found liable for a case of battery against the Wookiee? First, did I act? Yes, I voluntarily punched Wookiee. 2, did I intend to cause harmful or offensive contact? Most likely than not, the courts would find my actions intended to cause harmful or offensive contact. 3, did a harmful or offensive contact result with Wookiee? From the looks of it, yes, it looks to be harmful, and a reasonable person would have found it offensive. And did he consent? I didn't hear him. I know he complained. Didn't mean he consented. So he did not imply consent, nor was it explicit. And I didn't get anything in writing, so it wasn't explicit. It seems as if all the elements of a prima facie case of battery against me are met. However, I may be able to assert a defense against the battery. Now, these defenses include self-defense, necessity, consent, and accident. Let's go through each one of these defenses in more detail. For defense, if a defendant reasonably believed that they were going to be attacked, they have the right to defend themselves. However, they would be required by law to take reasonable steps to avoid resorting to force. In addition, you're not allowed to use more force than is reasonably necessary to defend yourself. Some states, such as Massachusetts, may require that you must attempt to retreat if such a means is available before resorting to the force. Now, if you're home, you're not required to retreat typically, so as long as you believe the intruder is about to inflict great bodily injury or death upon you and you use reasonable means to defend yourself, you might be able to do self-defense. Next, the defense of necessity or duress is available to a defendant when exceptional circumstances exist. To assert this defense, the defendant has to demonstrate that based upon the facts and circumstances, breaking the law caused significantly less harm than if the defendant had complied with the law. Consent is the next possible defense to battery. If individual consent to offensive touching, the defense of consent may be available. An example of this consent to offensive touching when one occurs is playing sport or contact sports within the constraints of normal, not malicious play. Lastly, if the touching that occurred was accidental, one may be able to successfully assert the defense of the accident. Since an element of battery requires that the touching be intentional, if you can prove that the touching was accidental, you may not be found guilty of intentional battery. So as a review, what did we learn today? First, that battery is an intentional tort. Remember that a tort is some kind of wrongful act that causes harm to someone else. That to prove a prima facie case of battery, certain elements must be made. Those elements are the defendant has acted, the defendant has intended to cause harmful contact or offensive contact, or plaintiff's immediate apprehension of such a contact with the person of the other or a third person, and the harmful contact has resulted, and that the plaintiff did not consent. If these elements are not met, one may not be found guilty of battery. In addition, there are defenses such as self-defense, necessity, consent, and accident that could also be used to shield you from a guilty battery verdict. I think the biggest lesson to be learned, though, is that if you find yourself in a confrontation with a Wookiee Perhaps it's better to talk it out over a nice cup of tea than to resort to violence. Now, should you have any more questions about this topic, feel free to give me a call at 1-888-BATTERY. That is 1-888-228-8379. We're standing by the phones waiting for your call.